Labana. Are y'all ready? Kicau, kicau, kicau mania. Kicau, kicau, kicau mania. Kicau.
You don't always act alone. Sometimes someone else steps in to negotiate, signs contract or make decisions on your behalf. But when that happens, a key legal question arises. Are you bound by what they do? The answer lies in the law of agency. Under Malaysian law, specifically Section 135 to 191 of the Contract Act, this situation falls under the law of agency. According to Section 135, an agent is a person employed to do any act for another or to represent another in dealings with third parties. The person who gives this authority is known as the principal. In simple terms, an agent is a representative of the principal. When an agent acts within their authority, their actions are legally treated as the actions of the principal. This means the contract is actually between the principal and the third party, not the agent. So, agency involves two important relationships. First, a contract between the principal and the agent, and second, a contract between the principal and the third party created through the agent. Interestingly, an agent does not need full contractual capacity. Even a minor can act as an agent. However, under Section 137 of the Contracts Act, if the agent is a minor, the principal cannot recover any losses from the minor. An agency relationship can be created in a number of ways under Malaysian law. First, express appointment. Second, implied appointment. Third, ratification. Fourth, necessity. And finally, estoppel. Importantly, under Section 13 Act of the Contract Act 1950, no consideration is required to create an agency. This means the relationship can exist even without payment or a formal agreement. To summarize, every agency relationship involves four key elements. First, the principal, the person giving authority. Second, the agent, who the person acting on behalf of the principal. Third, the authority, the power granted. And lastly, the third party, the person the agent deals with. Now, we are diving into the how and the what of creating an agency. We will explore the statutory requirements, the landmark cases that define them, and why understanding these boundaries is crucial for anyone doing business in Malaysia.
Yeah, I know, but yeah, I'll try to make a man of it. Okay, thank you. Natasha, thank you for being here. I really need help with managing with my business. I have a lot of customers these days and deliveries.
What you need me to do, I can help you. Okay, I can.
Sure?
Yeah.
Well, if so, then I'll appoint you as my agent, so you can handle all the customers' matters regarding all the orders as well as the deliveries.
No worries, I can do it.
Really?
Yeah, I can.
Agency can be created in a number of ways. Most commonly through express or implied appointment. Does it need to be in writing? Not necessarily. In the case of KGN Jaya Sdn Bhd and Pen Reliance Sdn Bhd, the court clarified that the law does not strictly require an agency or even sub-agency agreement to be in writing for it to be valid. However, oral doesn't mean easy to approve. Take the case of Singham, Sulaiman and Mega Palm. Here, a plaintiff claimed unpaid real estate fee, alleging they were orally appointed by CEO. The issue is whether there is a binding contract. The court dismissed the claim. Why? Because there was no positive evidence to establish that this oral appointment actually happened. The lesson is, while oral agreements are legal, they are incredibly difficult to enforce without a proof. Let's look at the express appointment under section 140. An authority is expressed when it is given by words either spoken or written. This is the clearest form of agency because it involves the actual concerns of both principal and the agent. It is the consensual relationship. But even written words have a limit. In the case of the Bank Bumiputra and Henry Ginai, the court looks at authority given under the power of attorney. The court ruled that this document must be strictly construed. In the case, the attorney acted outside the scope of his special power by charging the land for his own personal use. Because he exceeded the express authority granted to him, the court held that he had overstepped his legal boundaries. In conclusion, appointment of agent can be made orally, but the proof is vital and the express authority is strictly interpreted.
Meanwhile,
Cause I'm lost in the way you move, the way you feel.
Excuse me, can I purchase this car?
Yeah, sure, I can proceed for you.
a few moments later.
Hey Amira, thank you for helping me today. You have been really handling the customer really well.
Thank you. I'm just typing up for you since you're busy.
Thank you.
The second type of creation of agency is implied appointment, which arises through the implied consent of both the principal and the agent. Implied consent may be derived from the words or conduct of the parties, essentially based on how they behave in a given situation. Even whereas nothing is expressly stated, their action may indicate the existence of an agency relationship. Under Section 140 of the Contract Act 1950, authority is said to be implied when it can be inferred from the circumstances of the case. This includes matters that are spoken, written, or established through the ordinary course of dealing between the parties. There are three main situations in which implied appointment may arise. So first, through words or conduct. This occurs when a person, by their statements or behavior, represent another person as their agent to a third party. For instance, where a principal consistently allows another person to act on their behalf in business transaction without objection, the law may infer the existence of an agency relationship. Consequently, the principal will be bound by the acts of that person. Second, the relationship between the husband and the wife. Traditionally, a wife is presumed to have authority to pledge her husband's credit for necessity, such as food, clothing, and basic living expenses. This presumption is based on husband's duty to maintain his wife. However, this may be rebutted if the husband expressly prohibits such purchases or already provide sufficient maintenance. In modern context, this presumption has become less significant. Third, the relationship between partners. Under Section 7 of the Partnership Act 1961, every partner is regarded as an agent of the firm and of the other partners for the purpose of the business. Therefore, any act done by a partner in the usual course of the partnership business will bind the entire. So, for further illustration, the case of Chan Yin Ti against William Jacks and Co. is relevant. In this case, Chan represented that Yong, a minor, was his business partner. Yong subsequently purchased goods but failed to make payment. When the seller claimed payment from Chan, he refused. The court held that Chan was liable because he had represented Yong as his partner and the third party had relied on that representation. Therefore, Chan was not entitled to repudiate the contract. Similarly, In Edmonds against Bushell and Jones, 8065, the court illustrated the doctrine of usual authority. In this case, Jones employed Bushell as the manager of his business but expressly prohibited him from accepting bills from exchange. Despite this, Bushell accepted the bill and the plaintiff sought payment from the Jones. The issue here was whether Jones could escape liability for Bushell's unauthorized act. So the court held that Jones was liable. Bushell's position as manager carried with it the usual authority to accept such bills, and the principal's private restriction could not affect an innocent third party who relied on the agent's apparent authority. This case reinforced the principle of apparent authority, where a principal may be bound by acts of an agent that falls within the usual scope of their role, even if such acts were expressly forbidden. Apparent authority refers to a situation where an agent appears to have authority to act on the behalf of a principal, even though no actual authority was granted. It arises where the principal's words or conduct lead a third party to reasonably believe that the agent is authorized. In conclusion, implied appointment arises from the conduct, relationship, and surrounding circumstances of the parties. The law will hold a principal liable where the actions create the appearance of an agency relationship, particularly where third party rely on such representation.
The feeling won't let me sleep, 'cause I'm lost in the way you move, the way you feel.
Hi, I would like to purchase 100 units of this iPad on behalf of my principal. She already told me to buy them at 1,200 ringgit per unit.
I'm sorry, but I only can offer them at 1,400 ringgit per unit. Are you authorized to proceed with that price?
Yes, I'm handling this on behalf of my principal, and she already told me and authorized me to do so.
So, we agreed, right?
A few moments later.
Boss,
Yes?
I need to tell you something.
What is it, Alia?
Actually, I bought this iPad at 1,400 ringgit per unit, which is higher than what you authorized me to do.
Seriously, 1,400 ringgit per unit? You acted without my permission, Alia.
I'm sorry, but actually it is a good deal.
Alright, then I will accept it.
So you are approving what I did?
Yes, I ratify the contract.
What happened when someone acts without your permission or exceed the power you give them? Under Section 149 of the Contract Act, you have a choice. Either you can disown the act or you can ratify it. Ratification is the approval by act, words, or conduct of an agent unauthorized behavior as noted in Hetman against Hornsby. Ratification effectively clothes an authorized act with legal authority, curing the origin defect as if the agent had permission all along. Ratification is not automatic. It must meet strict legal criteria. The act must be unauthorized. It must be an act that recognized by law. The agent must expressly act as an agent for the principal, not for themselves. The principal must be in existence or actionable when the act is done, and importantly, the principal must have the contractual capacity both when the contract is made and when it is ratified. Furthermore, the principal must have full knowledge of all the material facts. You cannot pick and choose. You must ratify the whole contract. It must be done within a reasonable time. And finally, ratification must not injure a third party. Let's look at the requirement that an agent must act as an agent. In Caleb McStees and Co. against Duran, an agent was authorized to buy wheat at a certain price. He exceeded that price and bought it at a high one, but he bought it in his own name. The court held that the principal could not ratify this. Why? Because the agent didn't tell the seller that he was acting for someone else. You cannot ratify a contract that wasn't made in your name. Next, in Kellner against Baxter. What about the existence of the principal? In Kellner against Baxter, a group of promoter bought a hotel on behalf of the company that had not been registered yet. When the company had eventually formed, it tried to ratify the purchase. The court said no, you cannot ratify a contract if the principal did not legally exist at the time of the contract was signed. And lastly, in the case of Metropolitan Asylum Boards against Kingham and Son, timing is everything. In the case of the Metropolitan Asylum Boards, an agent bought eggs without authority. The principal tried to ratify the deal 1 week later. The court held that the ratification was too late. To be valid, ratification must happen within a reasonable time, especially for perishable goods or time-sensitive market. Ratification is a powerful tool to validate an authorized act, but it is bound by strict rule of transparency, existence, and timing. It turns a wrong into a right in the eyes of law, provided you follow the 10 golden rules of Section 149.
Durian! 1 kilo, 10 ringgit. Alia, can you help me wash my durians? I want to go out for a while.
Okay, my dad, don't worry. I will take care of them.
Okay, thank you, Alia.
Oh no, today is so hot. Some of these durian are already cooking. If I leave this here, all of them will get spoiled. Oh no, Maita, please answer, please. Maita, please answer. Why she's not picking up? If I do nothing, Maita will lose her money. I can't let that happen. Okay, I will sell all. Wow! Fresh durian, cheap price. Get them before it's spoiled. Saya jual.
Saya beli.
Saya jual. Terima kasih.
3 hours later.
Alia, our durian is already sold.
Yeah, I'm sorry, Maita. Actually, I sold all of the durian in a cheap price because the weather today is so hot. I'm afraid the durian will become more spoiled. So yeah, I sold them in a cheap price to prevent the loss of the business.
Oh, it's okay lah, Alia.
Today, I will be explaining one of the way an agency relationship can be created, which is agency by necessity. This creation of the agency is governed under Section 142 of the Contract Act 1950. Agency by necessity arises in emergency situation where an agent is allowed to act without the principal's prior authority in order to protect the principal from suffering loss. In such circumstances, the law recognizes that the agent may need to make immediate decisions and therefore give the agent authority to act as a reasonable and prudent person would in a similar situation. However, for agency by necessity to exist, there are certain requirements that must be fulfilled. Firstly, it must be impossible for the agent to communicate with the principal. This means that the agent must show that there was no practical way to obtain instruction from the principal at the material time. If the agent had the opportunity to contact the principal but failed to do so, then agency by necessity will not arise. Secondly, the action taken by the agent must be reasonable and necessary. The agent must act in a way that a reasonable person would act in order to prevent loss to the principal. The action taken must not be merely convenient but truly necessary under circumstances. Thirdly, the agent must act in a good faith. So this means the agent must act honestly and in the best interest of the principal, without any intention of gaining personal benefit. The agent's conduct must be bona fide and aimed at protecting the principal's property or interest. This principle can be illustrated to case law. In the case of Prager against Batsfield Stamp and Heacourt Limited, an agent purchased furs on behalf of the principal during wartime. However, due to the war, the furs could not be delivered. The agent later sold the furs when the value had increased. The court held that there was no agency by necessity because the goods were not in immediate danger of deterioration and could have been preserved by proper storage. Therefore, the sale was not necessary. Similarly, in the case of Springer against Great Western Railway Company, tomato belonging to the plaintiff were delayed in transit and began to deteriorate. The railway company decided to sell the tomato without informing the owner, even though it was possible to communicate with him. So the court held that there was no agency by necessity because the company had the opportunity to contact the principal but failed to do so. In the case of Sage against Miklos, the defendant was storing the plaintiff furniture for free. Later, he needed the space for himself and could not reach the plaintiff, so he sold the furniture and claimed he was an agent by necessity. However, the court ruled no agency by necessity existed because there was no real emergency. The furniture was not perishable or at risk, and the defendant sold it for his own convenience, not to protect the plaintiff's interest. Because he acted for his own benefit and not in a good faith, he was liable for conversion. This case shows that agency by necessity only arises when there is a genuine emergency, the principal cannot be contacted, and the agent act in a good faith to prevent loss. Here, none of these conditions were met, so the defendant had no legal protection for selling someone else's property. In Norton against Seymour, a shipmaster was in a foreign port with a damaged ship that needed urgent repairs. The owners was not in design and could not be contacted, so the shipmaster paid for necessary repairs to save the ship and later claimed reimbursement as an agent by necessity. The court agreed, holding that the agency by necessity did existed because there was a real emergency. It was impossible to get instruction and he acted in a good faith to protect the owner's interest. He was therefore entitled to reimbursement for the repair costs. This case shows when an agency by necessity does apply, when there is a genuine emergency, the principle cannot be reached, and the action is necessary to prevent loss, the agent acts in a good faith. So the shipmaster fulfilled all these conditions, so the law recognizes his authority and protects his right to be repaid. In conclusion, agency by necessity only arises in a genuine emergency situation where it is impossible to communicate with the principal, the agent's actions are reasonable and necessary, and the agent acts in a good faith. If any of these elements are not satisfied, then the agent cannot rely on the doctrine of necessity to justify their action.
Later.
Hello.
Hi, yes?
Do you have any update on the project that we have discussed before?
You can go ahead with the project. I will approve it for our company.
Are you sure that you have the authority?
Yes, I handle this matter.
Alright, I will start the work.
Okay.
Thank you.
Many months later.
So I'm the developer for the project that we've discussed before. So the project is completed and here's the payment invoice.
Lina was not authorized to approve this project.
But she acted like she had the authority and you didn't stop her. I trusted your company because of what I saw and you let her act as your agent.
You cannot say anything about this at that time.
Then you cannot deny it now.
An agency relationship is created even when parties do not specifically intend to sign a contract. This is known as agency by estoppel. It is a constructive form of agency, meaning it is created by the imposition of law based on the conduct of the parties. The main purpose of this doctrine of estoppel is protection. It prevents a person from denying a state of affairs that they previously represented as true. Specifically, it protects a third party from suffering a loss if they change their position based on the assumption that an agency relationship actually existed. Then, how does this actually work? If a principle, through words or conduct, allows a third party to believe that someone is their agent and that third party relies on this belief to their own detriment, the principle is stopped or legally stopped from later denying that the agency actually existed. Freeman and Lockyer and Burgess Park Properties is about agency by estoppel, which happens when a principal allows someone to appear as their agent even if they don't actually have authority. In this case, Mr. Kapoor acted as the managing director of a company and hired architects without formal permission. The other directors knew about this but said nothing, so the architects reasonably believed that Kapoor had authority. The court held that the company was liable because it held Kapoor out as having authority through its silence. This created agency by estoppel, meaning the company was stopped prevented from denying couples authority and had to pay architects. This case set out 4 conditions of ostensible authority, which are: there must be representation to the third party, made by someone with actual authority, the third party must rely on it, and the principal must have the capacity to contract. In Malaysia, this case is widely used to explain Section 190 of the Contract Act 1950, which states that if a principal's word or conduct make a third party believe someone is an agent, the principal cannot later deny that agency. This protects third party who act in good faith and ensure principals are responsible for the appearance they created. So the key principles of creation of agency through estoppels are: constructive, it is created by law; then it prevents denial of agency; and last but not least, protect third parties from detriment. In short, agency by estoppel ensures that you cannot lead someone into a business deal, then pull the rug out from under them by claiming that person wasn't actually my agent. Your action speaks as loudly as your contracts.
My transistor radio comes from far away, and when it's night over here, over there, it's breaking day. I remember all the good times I had walking in the sand.
So, please menyimak the subject matter of the sale, subject matter of the transaction, but only 2.
Wait, I don't understand. I don't understand either. Wait, do you guys understand?
Guys, do you actually understand on our last lecture the type of agent one? I'm still a bit lost.
Same here. I think some part, but there's still some part that are still confusing.
Which part are you confused about?
The factor agent one. I still could get how it works.
Oh, it's actually like this. A factor agent is a middleman who is given goods by the owner to sell. The key point is that the agent has possessions of the goods. He keeps the goods, for example, in a shop or showroom, and can sell them in their own name, collect payment, and then pass the money back to the owner after taking the commission.
That makes more sense now.
Then how about commission agent? Can you solve it?
A commission agent is basically someone who helps to buy or sell the goods for the principal. They don't own the goods and they get paid through the commission, which means they earn a percentage for every deal they manage to complete. So basically, the more deals they make, the more money they get.
Can you help me sell these cookies? You will earn a commission for every sale you make.
Okay, I will help you sell them and earn commission for each sale.
Then, how about the delivery agent?
That's fine. A delivery agent is a special type of agent who acts as both negotiator and a guarantor for the principal. Unlike a normal agent, they take on the personal risk of the transaction. If the buyer fails to pay, the delivery agent is legally bound to pay the principal themselves. Because they take on the risk, the extra risk to protect the principal from bad debts, they earn an additional commission on top of the standard fee. This is known as a delivery commission. Basically, the more risk the agent carries, the more they get paid for providing that financial safety net.
I understand. What about the broker agent?
A broker agent is basically someone who acts as a middle person to negotiate and arrange a deal between a buyer and a seller. They do not have possessions of the goods. They only help both parties reach an agreement and earn a commission. Once the deal is concluded, their job is finished. So basically, a broker agent only arranges the deal without holding the goods, while a factor agent holds the goods, sells them, and handles the payment.
This house looks nice.
Yes, but who is the one selling the house? I would like to buy it. You can deal with me. I am the broker acting as a negotiator between you and the owner, and I don't own her house. As a middle person, my job is to connect both parties, explain the property, and help arrange the deal.
Oh, so basically they just act as a middle person, right?
Yes, exactly. Okay, nice. What about the power of attorney?
From my understanding, a power of attorney is a legal document where a person gives another person authority to act on their behalf. So this allows the person to sign the document and handle the matter for them based on what is written in the document. So it is different from other agents because the authority is given commonly in writing and it gives a wider power compared to the normal agents.
I appoint you as my attorney through this document. This means you are given the authority to act on my behalf for this matter.
I accept the authority given to me, and I will act on your behalf as stated in this document.
So it's basically a legal document that allows someone to act on the behalf of another person, right? So I understand now.
Oh, okay. Now everything is much clearer. Yeah, discussing like this is very helpful. True, I feel more confident now. Thank you, guys.